Judge Tom Campbell from Fulton County. Judge, always a pleasure to have you with us. Is Judge McGarity? I'm sorry? Oh, okay. All right. Thank you, Sandy. Anyone else? If not, I also want to make some subcommittee assignments. If everyone will listen up, I'm going to ask that House Bill 980 by Representative Hughley be assigned to the Knox subcommittee, that House Bill 1071 by Representative Chuck Sims be assigned to the Knox subcommittee, that House Bill 1113 by Representative John Hurd be assigned to the Mumford subcommittee, and that House Bill 1136 by me be assigned to the Mumford subcommittee. And y'all will be getting out notices about when you will meet, I'm assuming.
We'll be having a meeting on your bill very soon, Chairman.
Good. Thank you very much. Good. Right answer. All right. First bill we're going to take up today is House Bill 960 by my friend Representative Lynn Walker. Representative Walker.
Thank you, Mr. Chairman. Members of the committee, every time I come before this committee, I'm always reminded of Peter and John before the Sanhedrin. The Bible says after further threats, they let them go.
I started to say, Representative Walker, for the members of this committee, you may have to elaborate on that story a little bit.
I think we'll move on, Mr. Chairman. General Assembly has historically recognized that there are crimes of such a severe nature that the appropriate venue of bail is in the Superior Court. And in many areas of our state, the drug that is commonly known as ecstasy has become extraordinarily destructive in our state. In fact, its sale and use in Georgia corresponds to many of the societal problems that are associated with other illegal and dangerous drugs. And at the request of a Superior Court judge in Gwinnett County, Judge Warren Davis, and also at the request of our Sheriff in Gwinnett County, Butch Conway, and our District Attorney, Danny Porter, House Bill 960 recognizes that the severity of selling and possessing and distributing the drug ecstasy has risen to such a degree that it should be bailable in Superior Court. This House Bill 960 is a bipartisan piece of legislation that is signed by all the members of the Gwinnett County delegation, and I ask for your favorable consideration for House Bill 960.
Thank you, Representative Walker. Questions from the committee?
I'll have a motion at the appropriate time.
Questions from the committee? Vice Chairman Mumford.
Move to pass. Second.
We have a motion that that House Bill 960 be. I'm sorry. Was that a question? No. Okay. We have a motion that House Bill 960 be given a due pass recommendation. Is there discussion on the motion? Is there discussion? All in favor of the motion, please indicate by raising your right hands. All opposed? Representative Walker, when the word gets out about your success in this committee, you will be asked to carry bills by other members of the House down here.
And this committee.
And this committee.
Can you stick around?
Thank you.
This one?
Thank you, Mr. Chairman, members of the committee.
Thank you, Representative Walker. We'll next call up House Bill 922 by a former member of this committee, Representative Jacobs. It's good to have you back.
Thank you, Mr. Chairman. It is always a pleasure to be back before this august committee. Mr. Chairman, members of the committee, I bring before you House Bill 922, and before I get too far down the road, let me pass this around. House Bill 922 is intended to deal with a situation we had in my home county of DeKalb where local, unelected, high-level local officials were structuring contracts, apparently at the request of the vendor, were structuring contracts below the competitive bidding threshold for public contracts in DeKalb so that they did not have to be competitively bid. As you can see from what I have passed around, this is a letter from the vendor, and obviously, I mean, there had to have been some consultation between someone within the county and the vendor for this letter to exist in the first place, because the competitive bidding threshold is $50,000. They were requested to structure these contracts for IT consulting services below that threshold at $49,500. There are 5 of them here, and then as you can see, if you turn it around, if you turn the page over, those 5 purchase orders below the competitive bidding threshold were paid for with one check for $247,500. The competitive bidding threshold at issue here, and let me say, I mean, this does not affect any local government's competitive bidding threshold. That is something that is a function of either local ordinance or, in the case of DeKalb, local legislation. It is something that is in our county organizational act. But here you can plainly see that there were several contracts below the threshold, several purchase orders below the threshold for the same services, and then those purchase orders were paid with a check that was well above the threshold, and was well above the threshold not just for competitive bidding, but also a $100,000 threshold that is in the Organizational Act for approval of these contracts by the County Commission. That approval never occurred. So that is the problem this bill is designed to address. This bill obviously, or as you might guess, had some significant interests from some of the larger counties, and I actually did, between subcommittee meetings, this bill was heard in 2 separate subcommittee meetings, sit down with representatives of the 4 largest counties in the state, Fulton, DeKalb, Cobb, and Gwinnett, as well as ACCG and GMA, and attempt to address all of their concerns. Let me walk you very quickly through the provisions of the bill. Subsection A is a couple of definitions that actually were prompted by the discussions between subcommittee meetings. One concern was that a policy or procedure might not have had, the way the bill was originally drafted, might not have had to be in writing. Now it is clear that that has to be in writing. It could be a function of state law or county ordinance or some other written policy that is adhered to by the local government. Similar goods or services, there was some concern, as you can see further down, the elements of the crime talk about the same or similar services. There was some concern that since similar was not defined, you could end up with a situation like having a contract for, say, computer monitors, and then a contract for computer keyboards, and those could be defined as similar and then aggregated in order to trigger the crime here. This makes it clear that that whatever the goods or services are, they have to serve the same function in order to be considered similar for the purposes of the law. Subsection B contains the elements of the crime, and let me also say the reason that I have brought this legislation to create a criminal offense is that I was very surprised on inquiring with the prosecuting attorney's counsel in particular that there is no offense that fits this particular crime, which really is a fraud against the taxpayers. There is no specific offense that fits that fits the offense here. There is no specific crime that fits the offense here. And so in DeKalb County in particular, and DeKalb may tell you that they are in the process of auditing what occurred, and that is true. They are in the process of auditing what occurred, but and it's the county commission that at this point is leading that audit. But there is very little they can do, as a matter of county ordinance or state law in terms of actually effectuating some change if the other branch of our county government, the chief executive officer, decides to stand by these officials. And I'm not suggesting the chief executive officer has made any sort of decision to that effect. But this creates a very specific offense that says that we are serious about these competitive bidding thresholds. The elements of the offense are contained in subsection B. One change that we did make from the last, and this is the only substantive change from subcommittee, is pinning this to a single fiscal year rather than a single year. I believe before it was you would take the first contract and go out a year from that. This was actually a suggestion by the folks in Gwinnett County, and I accepted that suggestion, and it is now incorporated into the substitute version of the bill. Subsection C defines the penalties. First offense would be a misdemeanor. Second offense would be a misdemeanor of a high and aggravated nature. Subsection D is this was something that came up in the meeting between subcommittee meetings from a representative of the Cobb County government. He said, well, we competitively bid contracts below the threshold anyways. And I said, well, that's not the sort of thing that is intended to be caught by this legislation. So if you do competitively bid a contract below the threshold, it will not be aggregated in with other contracts to get you above the threshold. And let me also say that the standard here is knowingly, so it is a very high standard to meet in the first place. And finally, subsection E is a set of exclusions. One would, and this was language that came out of that meeting and was further perfected in discussions with ACCG, that says that if you have the elected officials take action afterwards, approving or ratifying whatever had gone before, or beforehand, for that matter, approving whatever had occurred that otherwise would fit this criminal offense, that would take it out of the operation of this code section. The idea is that if you have public officials who are accountable to the voters, deciding that what happened is okay with them and they're willing to raise their hands in a public meeting and vote with a majority to approve that, then it's okay. Subsection 2, E2, will make sure that one of the complaints about the original version of the bill was that all kinds of people in a purchasing department, especially in a large county, might touch a contract of this sort. The idea is to get to the decision makers, so we've exempted any actions of a clerical or ministerial nature. And finally, subsection 3 is something that deals with emergency situations. This was suggested by Mike Vaquer, representing the Fulton County government. So we've addressed everyone's concerns that were brought up in that meeting between subcommittee meetings. And this is where we stand now. ACCG remains opposed to the legislation. GMA is neutral on the legislation and supportive of it as a good government type measure, but not taking an official position. They are neutral. The Associated General Contractors are neutral on the legislation, but supportive of it as a good government type measure. And I suspect you probably will hear from individual representatives of those 4 large counties that I mentioned. There is still some consternation out there on the part of them, but I will say this. I mean, we gave everybody an opportunity to get any unexpected consequences on the table and get them dealt with, and we did deal with them in this legislation. And with that, I will be happy to answer any questions from the committee. Thank you, Mr. Chairman.
Thank you, Representative Jacobs. Representative Levitas.
Thank you, Mr. Chairman. I just first of all want to commend Representative Jacobs for his work between subcommittee and committee in addressing all the concerns of the stakeholders. I want to go back to your comment about there not being currently a law that really deals on all fours with this particular situation. And I believe it was either the Cobb or the Gwinnett General Counsel that, or County Attorney that testified before, and I believe it was her own testimony, the subcommittee hearing, that seemed to almost contradict itself. On the one hand, she said, we've already got laws in place that deal with this, it would be fraud, and then the following comment was, however, they're not getting any gain out of this, so therefore it wouldn't be really possible to prosecute them under fraud. So that really strengthens, doesn't it, your argument for the need for this bill to fit that gap, so because there isn't a particular piece of legislation on point?
I think that's exactly correct. At best, you do not have an offense that is on all fours, or as I said in subcommittee, even 3 or 2 with the elements of this offense. I mean, it would be very difficult to prosecute. It can be dealt with by local ordinance, but you know, the way local governments deal with it is widely disparate. And at the end of the day, I think it is important that we have an offense that says that we are serious about public contracting safeguards, because they are meant to ensure that the best possible services are obtained at the lowest possible cost to the taxpayers, and going around them intentionally, or in this case knowingly, is truly is a fraud on the taxpayers.
Thank you, Mr. Chairman. Thank you, Representative Jacobs.
Vice Chairman Mumford.
A couple of questions. You indicated that what you described was a fraud on the taxpayers of DeKalb County. How was it a fraud on the taxpayers of DeKalb County? What were they defrauded out of?
Well, I mean, they were. It is clear that we have with this, you know, with this example, we have they were. And how shall I say this? It is clear that we have a situation where a particular vendor was given some sort of preferential treatment for some reason by unelected members of the county administration. All right? And it is further clear that if you take what you have here and you add it up together, all right, you ultimately have a contract for these particular IT consulting services that should have been competitively bid. And can we say, sitting here today, that that there is no other vendor out there? I would suspect, given that it's IT consulting services, there are other vendors out there who should have been
You're not suggesting that we ought to pass a law on what your suspicion might be.
No, I'm not. What I'm saying that is that, and first of all, this would not apply retroactively to the situation in DeKalb. All right, I mean, this is not ex post facto. It is going forward, and it is meant to say that we are very serious about these public contracting safeguards.
Can I ask just a couple of follow-up questions? If it was found that, for instance, someone had given something of value to one of these county employees, they would be prosecutable under the current law. Is that correct?
That would certainly be correct.
Okay. And if one of the county employees, if it was proven that their motive in doing this was to direct county business in an improper way to someone who was not qualified or to someone who was related to them, that would also be currently against the law. Is that correct?
That would be correct.
If I might follow up with one. Sure. If I understand this correctly, this particular law that you are proposing would have an important portion of it which is not set in state law. That is, the trigger requirement would vary from government to government, county to county, based on whatever the county's policy was.
It would,
or the government's
no,
policy?
it would require a written policy on the part of the local government, whether that is done somehow administratively under the, under whatever the legal scheme is that governs procurement within the county. But it would, no, it would only apply to thresholds that are, that are written as a matter of policy, including ordinances and for that matter, local laws that are enacted by the General Assembly.
So we could basically, by passing this law, have a state law which has a different application in every county, city, and school board, or any other government agency. There's other boards that are out there. Every one of them could have a different rule as to where the trigger is. Could that create any confusion?
No, because the elements of the crime are pretty clear. The threshold in the it is true that different jurisdictions will have different thresholds, and that is the only variable in this.
Is it legal for a county to have no threshold today?
I don't. Well, that certainly would be. That is a good question that sitting here today I do not know the answer to, but it certainly would be bad policy.
Bad what
Policy.
kind of policy?
Bad policy.
Accounting policy?
No, bad
Criminal policy.
bad public contracting policy.
Okay, would it be criminal?
If
Only
you
if you're bill
if you Representative Mumford, if you are doing this, then I would suggest to you that you have committed something, that you potentially have done something that is tantamount to a criminal offense, but it is not a criminal offense today.
Well, but you have that letter, but when I asked you what the fraud on the taxpayers was, I didn't hear a specific statement as to what the fraud on the taxpayers was.
The fraud on the taxpayers is that the taxpayers have the right with these public contracting safeguards, and that's why I say it's bad policy to not have a threshold. But the taxpayers have a right with these public contracting safeguards to receive the best possible services at the lowest possible cost. And when you're doing things like this, you're not ensuring that that happens.
I don't have any other questions.
Representative Nikki Randall. It was flashing before you got here. But is it yours? Okay.
It's mine.
All right. Representative Mangum.
To the distinguished gentleman, I too had some of the similar concerns that the previous question somewhat addressed, but you spoke to the organizational code on differing thresholds. Tell me, as a member of the DeKalb delegation, why you didn't come to the DeKalb delegation and bring this particular
I actually
legislation.
I actually did talk about this specific bill in a DeKalb delegation meeting. You were not there.
Well, I don't recall it, and that's really why I brought it. But
That's
you're saying
probably
that,
why.
When did you bring it?
Representative Mangum. I might have been last week or the week before.
Okay, last week. When was it brought before whatever subcommittee heard it?
There
You
are
said
no.
that there was a subcommittee that heard
First
this
of
particular
all,
legislation.
there are no subcommittees of the delegation unless created at the discretion of the delegation chair. That's the first thing. But the second thing is that this is general legislation, which, as a courtesy to the local delegation, I did discuss at a delegation meeting and discuss my intent to move it forward.
Well, I'm a member of the DeKalb delegation. I don't remember that. If you say I was absent, I had to be. But what I want to ask you is, are you familiar with Section 264 of the DeKalb Code?
Of the organizational, the DeKalb Code of Ordinances? No.
But you're saying that you're bringing this to resolve an issue and that there are no options where there is any problems that amount to clear fraud. And I'm very concerned, and I'm sure you're not doing this as an election year publicity stunt. I'm absolutely sure of that. But what I am asking you is, why didn't you, okay, it's my understanding that Section 264 indicates that if there is a complaint of any alleged violation of the code, that there is a procedure to address that. Have you addressed that procedure?
The Board of Commissioners is currently investigating this, led by one of my county commissioners, as a matter of fact, is currently investigating the situation.
Okay. When you say that they're investigating it, but are you aware that there is a specific procedure to have sanctions or charges against an officer, elective or appointive, when there is any alleged violation of the organizational act?
I will take that from you, Representative Mangum.
I'm surprised that it had not come up before now. As I sit here, this is my first time having an opportunity to speak to you about it. I am a member of the delegation of DeKalb County. You're a member, right? You have not specifically spoken to me about this, have you?
I discussed it at a DeKalb
Have you
delegation.
specifically spoken to me about it?
I have not specifically spoken with you about it, but I did discuss it with the members of the delegation who were present at that meeting.
Okay. Well, I'm very concerned because you make the allegation that there are clear violations, and in response to the questions of what is the clear fraud, I'm troubled about what that clear fraud is. Can you, again, try to answer that question?
Well, obviously there is an ongoing audit right now and an investigation. I am saying that from the documentation that I have seen, it appears that there has been some impropriety that is contrary to the competitive bidding safeguards for the county. Furthermore, and I certainly don't take everything I read in the paper as true, but if the amount if the amount that has been reported in the paper as being the result of this practice ongoing in DeKalb County is true, $20 million plus is a lot of taxpayer funds.
So you're coming to us today and saying that $20 million has been fraudulently taken from the taxpayers of DeKalb County? Is that what your allegation is today?
I did not say that, Representative Mangum. I said that there is an Atlanta Journal-Constitution article regarding the prevalence of this particular practice within the DeKalb County government that puts the dollar amount of contracts that have been awarded in this way at greater than $20 million. And I view that as a significant problem, assuming that it is true.
Assuming that, so you want to, well, if that is true, I am sure that there are many, would you venture to say, as a lawyer, and I believe you do or have done criminal law, is that correct?
No, I am not a criminal practitioner.
Okay, but you are a lawyer.
I am a lawyer.
You know the elements of fraud.
I do indeed.
And you're saying that fraud would not cover this matter?
Well, you're talking about civil fraud, though.
I'm talking about any fraud you want to, whether any type of fraud you want to bring before the bear, because I'm just concerned that these are very serious charges you're bringing. And you're bringing them in the context of some organizational code that specifically deals with DeKalb County. Isn't that correct? But you're saying it will have implications all over the state of Georgia.
That is correct.
And if I have a threshold of $25,000 to do contracting in Chatham County, for example, Chatham County would still be subject to this particular law that you're bringing today, is it not?
Absolutely.
I'm troubled further because you have evidently in your negotiations with ACCG, is what you just indicated, that any actions approved or ratified by a vote of the governing authority of the county or municipality or the local board of education would not have the sanctions that you've placed in your bill. Is that correct?
Well, would not qualify for this particular criminal offense. That's correct.
Mr. Chairman, I think I'm going to pass, but I just want to ask one or two more questions, and that is, what was the reason you did not come? Why did this not come through the DeKalb delegation?
It did, Representative Mangum.
This is not a local legislation, sir.
It's not. It is a valid area for statewide policymaking.
And I presume that we will hear from some of the other I can just think of many consequences just from my limited knowledge of what you're trying to do. If someone is doing a wrong act, and if Mr. Richard Stogner is committing a crime in DeKalb County, he should go to jail like anybody else. And evidently, I hope that this is not some kind of personal vendetta you having with Richard Stogner, because all I see is the paper you gave out today has Mr. Richard Stogner's name on the documentation. Is that correct?
I can assure you that it is not. In fact, I do not know Mr. Stogner well.
Well, but you did make the statement that there was clear fraud being perpetrated in DeKalb County, and you even went further to state that some newspaper saying that there's $20 million out there somewhere that's being.
Well, it's not some
wrongfully
newspaper.
taken.
It's not some newspaper. It's the Atlanta Journal-Constitution.
With all due respect.
Need to catch your breath, Representative Mangum?
Yes, sir.
Okay, thank you. All right, Representative Bearden, and then Representative Ramsey. We've got a lot of lights on, and people are signed up to speak.
Mr. Jacobs, again, I appreciate you bringing this bill forward. And Mr. Representative Jacobs, appreciate you bringing it forward. Again, this is not a local bill, correct?
That is correct.
So that's in the proper place then, because this will deal with statewide counties and school boards and things such as that has bidden practices, correct?
Well, that is correct. And as a courtesy, I mean, I did discuss it with the DeKalb legislative delegation because it deals with a particular situation that has gone in the past in DeKalb.
I want to get back to a question the vice chairman asked, reference to fraud to the taxpayers. I guess we got to use the word potentially, because with the handout you gave out, it's definitely troublesome, but we got to use the word potentially because the contractor could have been the winning bid, but someone could have came in at $200,000, and then the fraud is $47,500 to the taxpayers of DeKalb or any jurisdiction this may occur, which could run up into millions, if not hundreds of millions, across the state. Is that not correct?
Yeah, that's correct.
Again, I do greatly appreciate you bringing this bill forward. I just want to clarify those couple areas, so thank you.
Thank you. Thank you, Representative Bearden.
Representative Ramsey, and
Thank
then
you. Thank you, Mr. Chairman. Just so I understand the process, the way it would work if your legislation's enacted, Representative Jacobs, if a county purchasing agent buys a lot of widgets and that is below their threshold for competitive bids, and then 3 months later wants to buy another lot of widgets from the same vendor, and the two aggregated together would trigger the threshold, would they have to competitively bid that second lot even though it's below the threshold, but because it would, when aggregated together, would trigger the threshold? Is that the way it would work in your mind?
That would be correct.
And do you know, are there any counties or municipalities that have any procedures in place that prevent competitive bidding below a certain threshold? I'm sure you've looked at a lot of these.
That is a that actually is a worthwhile question that I do not have the answer to.
Okay. All right.
And frankly, would, you know, if it would give the committee some comfort, would certainly be, I would welcome an opportunity to hold the bill over and
Right.
and deal with that unintended consequence. Now, I will say this. We did, I did invite ACCG and all of the stakeholders that showed up at that first subcommittee hearing to sit down with me and ferret out any unintended consequences. And that is, I mean, this bill is actually more extensive than what was originally filed, and does deal with everything that was brought to light in that meeting.
Okay. Well, I just appreciate you bringing this forward. As a resident of a county that has a threshold, I appreciate the protection that these thresholds provide me as a tax-paying citizen, and I appreciate you bringing this issue forward.
Thank you. Thank you, Representative Ramsey.
Representative Lunsford, and then Representative Levitas.
Thank you, Mr. Chairman. Representative Jacobs, I have a question for you. Part of my district has some old cities in it, such as McDonough. Mm-hmm. The city of McDonough is a little bit unique, and that is that we still have some of the old original clay sewer and water lines in that city. So when one of those lines breaks, it's not a situation where we have time to do a competitive bid, anything. We've got raw sewage. They fix it. They call in a contractor to immediately fix it. Now, could that contractor be above the limit? Yeah, it could be. We don't have time for a city council vote. We don't have time for anything. But it happens all the time. So under this legislation, if they actually did a repair and then 1 month later we had another break, would we have to competitively bid the process for the second break, or would they be in violation of misdemeanor, because now we would be beyond the threshold limit?
Well, and that is what we were trying to get at with subsection E3, which is.
I saw that about the city council vote, etc.
No. That is an emergency situation where action is necessary to protect the health, safety, and welfare of the citizens.
E3.
And certainly, I would think a sewer system would qualify.
I was just curious.
Yeah.
Thank you.
That was one of the unintended consequences that came out in those discussions.
Representative Levitas, and then Representative Randall.
Thank you, Mr. Chairman.
I got both of you. Okay.
I will certainly stand to be corrected by my colleague, Representative Mumford, who's been in the position of being both a judge and a district attorney. My understanding of the general case laws in regards to criminal fraud is that in order to be prosecuted under there, the offender must realize some pecuniary benefit in order for it to be cause fraud. So I'm not asking for a comment. I'm just throwing that out there. Assume for purposes of this discussion that that is the case. In the case where a person knowingly avoids the threshold but does not realize any pecuniary benefit, any money, or other kind of monetary gain, you would agree that based on my definition, you don't have a common law fraud. Is that correct?
That'd be correct.
Okay. So do you think it is, in the general sense, when the layman, and I'll include myself in that, talks about a fraud, that we think of somebody as acting deceitfully? Would you agree with that?
Well, in the
general
colloquial sense,
right,
sure.
Right. Would you agree that all the citizens, whether they are citizens of a city, citizens of a county, or citizens of a state, or citizens of a country, are entitled to the honest services of their elected officials?
Oh, absolutely.
And do you think they're likewise entitled to the honest services of those appointed by their elected officials to perform certain duties for the county?
Absolutely.
Okay. So what your bill essentially is doing, as I read it, is where you are not captured, and this goes right to what Representative Munster was talking about, where you're not captured by a common law fraud. This addresses that specific provision where there is a knowing act aimed at depriving citizens of the honest services of their elected officials and those appointed to carry out the functions of the government. Is that correct?
That's correct, and I think it's also important to once again underscore that, I mean, the intent requirement here is knowingly, and that is a very high threshold to meet. Ultimately, you would need to know that you are that you are getting around a competitive bidding threshold by doing what you're doing.
Thank you, Mr. Chairman. Thank you, Representative Jacobs.
Representative Randall, and then
Thank
Representative Benfield.
Thank you, Mr. Chairman. Representative Jacobs, I was wondering, in the AJC article that you referred to several times about what other counties were cited in that article?
Well, the article was reporting on the situation that occurred in DeKalb, and that was it.
Okay, and so there aren't any references as to the other larger counties that you mentioned that may have had some similar situations in those counties?
No.
No. And a follow-up, if I may. You said that you offered this as local legislation in your delegation?
No, I did not.
You did not.
No, I think this is a valid area for statewide policy.
So you did not offer it as local legislation?
No, but I did discuss it in a delegation meeting because we had a recent situation in DeKalb.
And you mentioned earlier about the DeKalb Commission was investigating this particular event. Do you not feel that their investigation and the outcome of that investigation will be adequate to address this situation?
Well, in fact, it's going to have to be adequate because this law will not apply retroactively to what happened in DeKalb County. The bottom line is that what I am aiming at with this bill is a deterrent effect, an effect that says that we are very serious about competitive bidding thresholds and they should be complied with. This bill will not apply to the situation that occurred in DeKalb. That is a fact scenario that if it occurred after the enactment of this bill might be, the criminal offense might be applicable if the elements of the crime are in fact satisfied. But the hope is that it would not, that nothing like that would happen ever again.
Well, the thing that bothers me is that, and I'm from a whole lot, not in the top 5 that you mentioned, of course, but even in smaller areas.
But a great county, nevertheless. Sorry, go ahead.
Absolutely, without a doubt. But what bothers me is that the same situation that Representative Longsford mentioned, there may be situations in smaller counties where this may become problematic, and I'm wondering why you felt like that you should go statewide with this instead of addressing the situation that you had in your home county as local legislation. Because I haven't even had a chance to even talk with my local folks to see how this would affect a smaller county that sometimes have to deal with things quickly and without the resources that larger counties may have in order to address situations quickly. And so it concerns me that this is going to be far-reaching as far as statewide legislation instead of addressing a county and allowing a county's commission to have the opportunity to investigate these things internally. Thank you.
Thank you, Representative Randall. Representative Benfield, and then Chairman Knox.
Thank you. As I understand, and I apologize for coming late. As you can tell, I had some child care issues. But as I understand this, you're creating a new criminal offense called avoiding public contracting safeguards.
Well, that's correct, and actually there's a genesis to that as well. Originally, if you look at the caption of this bill, it would have gone under the the original version of this bill creates a new way to satisfy elements to fall under the deceptive business practices statute. But in talking through the bill a little bit further, including with some folks in the prosecutorial community, we came to the conclusion that it would fit better as a separate offense under the offenses against public administration chapter of the criminal code.
Okay, help me understand why it's better as a criminal offense as opposed to in the existing code sections for deceptive practices in the business.
Well, it would not fit under because of where you might go look for it in the code.
Okay, I still don't fully understand that, and I guess my issue is, well, first of all, this is a mouthful, avoiding public contracting safeguard crime, but I'm assuming you reviewed the existing existing law on fraud before you pursued a new offense. Is that correct?
That is correct.
Okay, and what specific code sections did you look at regarding the fraud? Because there's a lot of them.
It was in part, I don't want to get too far into that because part of that were my conversations with legislative counsel, which is, frankly, privileged. But, the bottom line is that we did try to ferret out whether an existing criminal offense, including all of the fraud-related offenses, would fit.
Well, I certainly don't want to violate any privileges, but I think it's helpful for the committee to understand why existing criminal laws don't cover the conduct that you're trying to get at. And I'm looking specifically at 16-10-22, conspiracy and restraint of free and open competition in transactions with state or political subdivisions. And I haven't done any research on this, so I'm assuming you, like you said, you did the research. But I would like to know why this code section in particular wouldn't cover what you're trying to get at, and if there are any other codes. I'd have to have more time to research it, but it just seems like existing law would cover the conduct without having to go about creating an entirely new criminal violation.
Well, for starters, I mean, one problem with the conspiracy statute, obviously, and I'd need to now go back and look at the statute once again, but one problem with a conspiracy statute is that it takes two to tango. I mean, this also would get at unilateral decisions that are made by public administrators, and for that matter, any attempts by a vendor to secure a contract that would be in derogation of the public contracting safeguards.
I still think that there are existing sections. I have to research it, but I think it would be covered by existing law.
Representative Knox.
Thank you, Mr. Chairman. I just wanted to follow up on a previous question about the aggregating of the bids.
Mm-hmm.
And, correct me if I'm wrong, but doesn't the bill have the provision that says have it like saving clauses in it? One of them being that if you, as long as it's voted on by the county commission or the governing body, whatever it is, none of this applies, right?
Right, that's
okay.
correct.
So that would solve that issue. The second thing would be with respect to the code section just cited about fraud. Most of those code sections are aimed at a contractor selling to the government entity, not at the entity. What you're dealing with is where the people violating these code sections are the persons that work for the government entity. Correct?
I believe that to be correct, too.
Okay. Thank you.
Vice Chairman Mumford.
I just wanted to take this opportunity because after I asked my questions, the meeting took a bit of a turn, I guess. But I certainly think that this is a valid issue, and I commend you for bringing it forward as well. My only concern is making sure we have a statute that is enforceable and is limited and is understandable by everyone.
Sure.
Just trying to get a good product here. That's my interest. And I know that your motives in bringing this are in the interest of the people of Georgia. So I commend you for bringing the bill.
Thank you. Thank you, Representative Mumford.
Final call questions from the committee. Okay, we have, where's my sign-up sheet? We have three speakers that wanted to be heard on the bill, and I would ask all three of them to be as concise as possible. The bill has been through the subcommittee process, and the committee members may have questions. We'll begin in the order that everyone has signed up. Morris Williams with DeKalb County. Come around, Mr. Williams. Glad to have you with us.
Mr. Chairman, distinguished gentlemen and ladies. Glad to be here this evening. My name is Morris Williams. I'm the Assistant County Administrator of DeKalb County, Georgia. And I would like to first reminisce on what actually happened in DeKalb that brought this action forward, then go through very quickly on what I think we should do. First of all, in DeKalb County, we try to run an open and fair government, as all governments in this state. I'm a county administrator by trade, educated at the University of Georgia, for some of you, which is the best university in the state, by the way. I've worked in the cities of Macon, Thomasville, Albany, Athens, and now DeKalb County. So I have 20 years of experience in administrating, and I've run departments. I've been a purchasing director, budget director, finance director, and now an assistant county administrator. The first thing I want to say is no one person in any government can make a decision. It usually takes 2 signatures to get a check. And that's really where your criminal activity begins, when the check is finally given. In DeKalb, for instance, in order for this procedure to happen, you have to have coordination between the information technology director, the purchasing director, the finance director, and then finally the administration. What does that mean? That means that either all these guys are colluding or we made some bad mistakes. I'm here to tell you that we made some bad mistakes. We violated our own purchasing procedures. We found that out. Ms. Mitchell is going to pass you out a document from KPMG, which is our auditor, and I'll direct you to the second page of that document, and it states, purchases and contracts. At the request of the Finance Department, we reviewed the purchasing and contracting procedures relative to the information system consulting services. In that, you'll find where this all began. I also contend to you that we had an internal audit done prior to the 2 audits that are being done. I know that you think there's one audit, but in DeKalb County, the CEO, based on the Organizational Act, has complete control over the purchases. So, when we found this out through our internal audit, CEO Jones ordered an audit from our side. Our county attorney's office is preparing an audit, as well as the Board of Commissioners. So we have an internal audit from the CEO's office, and we have an audit being done by the county commissioners. Thirdly, we also think this bill is premature for a little 2-word statement, due process. We think that this bill is trying to convict the actions of DeKalb County prior to our audits being done. We would like to have our audits done, share them with the public, which we plan to do, just as we shared the internal audit, and then give our commissioners the opportunity to take the necessary procedures. What are those procedures? The same ones we have anytime any malfunction of government happens. We have 4 of them, 4 of them. Number 1, we can call the district attorney's office, any of our commissioners, any citizen, and say, we think there's criminal activity. Can you please investigate? Here's what we believe. We can call the Georgia Bureau of Investigation. We think there's criminal activity. Here's the information we believe you need to investigate. We can call the U.S. Attorney's Office. We think there's criminal activity. Here's the information we think you ought to investigate. We can call the FBI. Here's the activity we think you ought to investigate. I think one of the things that we're overlooking is all governments are different. I've worked in 2 administrations in DeKalb County. During Ms. Levitan's tenure, where I started, our purchasing threshold was $12,500. It took us 6 to 9 months to get an RFP through. Our government was stagnant, and it took a long time to do anything as large as the DeKalb County government is. Various commissions have changed. They moved those thresholds up. We have policies and procedures here. I have a stack of them. I will submit them to you and send them around. You can look at any of them. But we believe that in DeKalb County, we try to do a fair job. Another thing I'd like to mention about the contractor in question. That contractor was on the GSA schedule of Florida, and I think he's on the GSA schedule of Georgia. We don't haphazardly just pick people to do contracts. But if somebody did haphazardly pick somebody to do a contract and we did find out it was fraud, it would not be a misdemeanor. In my profession, there are no misdemeanors. There are felonies. When you're found guilty of abusing government money, I don't know anyone that has gotten a misdemeanor. You get a felony sentence, a felony trial, and if you go to jail, it's going to be based on a felony. We think that in DeKalb County, this bill is just a little bit premature, and that it tends to take away from home rule. I think our commissioners deserve the chance, and our CEO deserves the chance to get to the bottom of this case and take the appropriate action. I think when they get to the bottom of this case, when the audit is complete, you will see them respond accordingly. They're not in the business of approving fraudulent acts. They don't stand for it, nor does the CEO. So with that, I think I've been as concise as I could be, sir.
And I appreciate that. Thank you, Mr. Williams. You stayed long enough to draw some questions, though. starting with Representative Levitas.
Yes, sir.
Good afternoon. I would agree with you picking up on your last point that it's premature to say whether there's been any criminal conduct here, and it's also premature to decide that there hasn't been. You would agree with that, correct?
The Constitution out here says you're innocent until proven guilty.
Right. And this particular act, even if they found some kind of malintent, obviously Representative Jacobs' bill wouldn't address that in this case. Is that right?
It would be over and above that, in my opinion. I'm not an attorney, but in my opinion, if the commissioners were going forward with any kind of request, it would not be about the splitting. It would be about the contract and fraudulent activity that happened as a result of the splitting.
Well, I guess what I'm saying is even if the conduct here violated Representative Jacobs' bill, since it hasn't even passed yet, obviously it wouldn't pick up on this particular case, right?
I think it would. Inside of our procedures that I'm passing around, it says splitting is illegal.
Okay. I guess I just have to tell you that my opinion, for whatever that's worth, is not, which is not much as an attorney, is that if the law wasn't in place, you can't be accused of having violated a law that didn't exist at the time. What I want to get back to is your conclusion, which struck me as very interesting. You set up a scenario that that the only two possibilities are that given the number of people that are involved in the chain of going from the contract to the signing of the check, that either everybody's is in collusion or you made mistakes.
I don't think I quite might have meant it that way, but yes, everybody is either included or we made mistakes, or you'll find that one person influenced everybody, which means everybody's guilty until they prove themselves out of it.
Well, let me suggest to you another possibility. Is it possible that either an appointive or elective official could be the sole person who knowingly is violating the statute and then tells folks to carry out ministerial functions like signing a check or submitting an invoice? Is that possible?
That is possible. However, an elected official would not do it in DeKalb County. It would have to be an appointed official. But as a result of your job, if you're the finance director, it's your job to check. If you're the purchasing director, it's your job to check and see if these things are violating the policies, and they have people they can appeal to. Number one, the CEO. Number two, the presiding officer of the county. So along with that, and it takes all those signatures to get a check, it would be their job. They would not be doing their job if they permitted it. It is not a thing that one person could do unless he said, you better do it, and you better do it, and you better do it. Otherwise, they're not performing their jobs. That's why it happened. In this case, I think it was more of a computer clerical error. In Oracle system, we have something called funds check. And that means if you purchase something from that department, and you purchase something from that department, and you purchase something from that department, but it's three different departments, three different purchase orders, and they come in, somewhere in there, the funds check will tell you, bing, 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 they've just gone over $100,000. That was off in the computer system for over 2.5 years. Same time, it was a brand new computer system. And a lot of those people that you see that were in those numbers that Mr. Jacobs talked about, State Representative Jacobs talked about, were used to help back up the computer system and install the computer system because, honestly, it was a little bit over our heads. We built a bigger computer system than we had the people to operate it. So a lot of those contractors were folks that helped operate that new Oracle system.
Okay, but you've seen the letter that Representative Jacobs, so I wanted to go over that. Tell me when you talked about the referral to the district attorney for prosecution, tell me generally what kind of prosecutions take place in the context of something like this, and what specifically are these folks prosecuted? What provision of the code? Because I know Representative Mangum had talked about the provisions of the code. As I read the code, the only people that would capture are appointed or elected officials.
The one word I can use is stealing. It happens all the time. We had a young man who was taking up money in the name of DeKalb County, however, putting it into an account under the Parks and Recreation Department. We caught him. We called the police, who did an investigation, who then called the DA, and they charged him for stealing. I don't know the great legal terms, but it was stealing, and that's exactly what I think this would be.
I think stealing is the right legal term. I guess my question is, where it doesn't involve somebody taking money, what are the code sections that you refer, and what code sections or ordinance provisions are they prosecuted under where they don't take money?
I don't think you can characterize it as they don't take money. I think it's an action that you do. For instance, as a public administrator, I could sign a document obligating the county to a contract. I have that authority. You go off to the bank, you get your loan, you start to work, but when you come back, they find out I couldn't do that. They charge me again with fraud, and I probably will go to jail. So in my opinion, anything that you do based on your signature or your authority, there's going to be a provision that says you did wrong. You're going to jail. I don't know exactly which one that is, but I'm pretty sure it'll happen.
Okay. Thank you, Mr. Chairman.
Thank you, Representative Levitas. Representative Collins. Representative Benfield.
Thank you. And I'm going to go back to the point that I had earlier. I think this is an extremely narrow code section that would be creating avoiding public contracting safeguards crime, when I think our goal with this committee should be to have general laws that are going to apply to as many circumstances as possible. And I do think existing law would cover this conduct. Again, I would need to do more research, but I wanted to go back to the point you made in your presentation about how this conduct would take several persons to to cause the fraud or the deceptive practice, that several folks must sign off on checks. And so I would just go back to the code section I cited, conspiracy and restraint of free and open competition in transactions with state or political subdivisions. I mean, it seems like it would be covered under existing law. This may not be the best code section, but I think there would be code sections that would be applicable. So I guess I want your comment on that.
I think I also just remember something else that would follow that lead. It would be using your position or authority to pull something off. Now, I'm no lawyer. I don't know what code section that is, but I know that's in there, where I would use my position to make my employees do something that I know is illegal. And I know that captures this knowingly, but it's already covered. As a public administrator, you're going to go to jail.
If I may just ask one follow-up, isn't it true that most of these conducts, I mean, I'm looking here at this code section, we're talking about felonies, and that was your presentation.
That's what we were afraid of.
Thank you, Representative Benfield. Thank you, Mr. Williams.
Thank
we
you,
appreciate your being with us today. The next witness that wanted the committee to hear him was Rick, is it Brun? Brun. Mr. Brun. We're happy to have you with us.
Thank you, Mr. Chairman. My name is Rick Brun. I'm Purchasing Director with Cobb County. I've been in public administration for probably 30 years plus. A lot of the points have been covered and well discussed at this point. I would have to say Cobb County does object to this law. We feel we're jumping the gun in terms of anticipating a problem that may or may not exist. It would definitely be infrequent. The premise of the law states that it will provide for a new offense of avoiding public contracting safeguards. We don't think it's anything new to that Cobb County and most local governments do have policies in place to address this sort of situation. Today is the first I've heard about the DeKalb situation in particular, and again, I do feel that's jumping the gun. I can think of numerous circumstances that the AJC could pick up on and make it clear cut that it's wrong, but there's ambiguous issues or technical issues that they're not able to understand and comprehend. But again, I just know what I've heard today. I haven't read the audit, don't know what the outcome will be. Cobb County again feels we're probably going to jump the gun by putting any kind of statewide law in place. We don't know all the ramifications of what would happen. In our case, we do, Cobb County, as you would expect, does quite a bit of purchasing. I've got a small staff, and we do decentralized purchasing. And listening to the discussion today, I can think of circumstances where our Parks Department might be budgeted for 2 tractors, let's say for $7,000 a piece, and they buy them, and they enter the requisition, and it goes through the system and goes through all the procedure. But then property management has a tractor breakdown, and they've got money in their budget, they buy it, and suddenly you're over $30,000 threshold, which is what the threshold is in Cobb County. We're a big county operation. There's departments that buy a lot of things, and the stats I'm looking at for 2007, just for things that went through the purchasing department, it accounted to over $120 million. Seal bids were very small percent of that, but it was over $30 million went through 190 sealed bids. Otherwise, on purchases that went from $1,000 up to the $29,999 figure, all those are competitively dealt with. For ones under $5,000, we do have the departments come in with verbal quotes. Anything above that, they have to have written quotes. They're subject to audit by us and review by us. We feel the system works well. And one other point would be the way I read the bill is that you would depend on or rely upon self-policing of the purchasing departments or the county themselves. And I have to say the ones that would abide by this are the ones that are already policing themselves already. It's just such as DeKalb County is and Cobb County. And the other folks, you're just going to have to kind of luck out in terms of finding them doing anything wrong. And again, I agree that I haven't had a chance to talk to our county attorney since I became involved in this today. But I do feel there's plenty of county and state federal law that would address most problems of collusion or any sort of bid rigging or purchasing inappropriate activity. That's basically what I have to say.
Okay. Thank you very much, Mr. Brunn. Before I entertain questions, I want to go ahead and make an announcement. We've got a couple of groups of constituents that are here from all over Georgia tonight, and the next bill on the calendar, although we carried over from the last meeting, I don't think we can take up in a few minutes. Author of the bill, is that an accurate assessment? So those of you that are here on House Bill 336, we're going to carry that one over. We've got a little bit more work to do, I think, on this one. Questions, and I just want to make that announcement in case anyone was here just for that one. Questions for Mr. Brunn, from members of the committee? Questions? Thank you, Mr. Brunn.
Thank you.
Todd Edwards with ACCG.
Thank you, Mr. Chairman, members of the committee. In the interest of time, I'll be brief with my comments. I think the previous speakers and questions from members of the committee had covered a lot of the concerns we initially and still had with the Association of County Commissioners of Georgia. I think, in short, the CAB itself has seen that perhaps there was a problem that is currently undergoing 2 audits. We don't know what those audits will find, what the recommendations will be. It could be that there was no attempt at fraud, or perhaps DeKalb's purchasing ordinance may need to be tightened, or even the Board of Commissioners might need to enact stricter penalties. We believe, however, that process should be played out. Again, DeKalb is aware that there may be a problem. DeKalb is looking at it. It's premature, in our opinion, to act now with a statewide law with statewide implications to address these issues. A couple of the points that I just wanted to highlight that came out from both the subcommittee hearing and the hearing today is that we don't see that there's a statewide problem that requires statewide legislation. I think the exception would be if there's a quid pro quo exchange for a personal benefit, any case of bribery, any case of fraud, but we also believe that those are currently covered by existing state law. Excuse me. What, in cases like this, if the second contract of the year is unrelated to the first? Just because they're somewhat related or similar, does that make it a crime? What if the bid by the vendor the second time in that year is the lowest and most responsive bid? And if taxpayers' cost would be higher if you didn't go with that bid? What if the vendor gave full value for the compensation received? Would this still be a crime under this law? It very well could be. There are also, in cases I mentioned, it was mentioned earlier about smaller communities that may not have that many vendors out there, that many contractors to either bid or submit proposals on a project. In smaller communities, there may only be a sole vendor that could provide that service. And again, this could capture that if that service was provided, that or a similar one, twice in 1 year over the threshold for a county or a city vote or a bid requirement. And lastly, in the examples that our members still had questions about, what if a particular vendor may be able to provide the best service and least expensive service, regardless of how many times a year that service is provided? I certainly don't think that would be any fraudulent intent on behalf of the county or the city in securing that particular vendor for a contract. In short, we believe this is a local issue and it was is best dealt with by a city or county in their local purchasing ordinances. Thank you all for your time and consideration.
Thank you, Mr. Edwards. Vice Chairman Mumford.
Good afternoon, Mr. Edwards. Do you know if Gwinnett County has taken an official position on this bill?
Last I heard from Gwinnett County is that they were opposed to this bill. They had concerns, and their lobbyist is in the audience. If Mr. Jet Tony, does Gwinnett have a position, Mr. Tony? I'm sorry, I didn't. Yeah,
If Mr. Mumford wants to ask me, I'll
Do you mind?
however y'all like to play it.
May I
I'm
ask
just here for ACC.
Mr. Tony what the position of Gwinnett County Commissioners is? Mr. Chair? May I? Mr. Tony, what is
If
the
he
commission?
chooses to answer.
I do. I don't want to be asked by the testifier.
Yes, sir.
Gwinnett County had significant input on this bill at the subcommittee level, and we appreciate that. And we had an opportunity to speak offline with the author, and we told him at that time we think the bill is a solution looking for problems, and that local ordinances and rules should be able to take care of this with existing state law. At this time, we would love for the bill to be held, and but as far as saying we're opposed to it and have the members of this committee that represent the county or a portion to have to be put on the spot about that, we're not willing to do that because we had significant input. And by the way, most of the things that we spoke to you about are in the bill, and we appreciate it. But again, we think it's unnecessary. But as to say opposed, no, I'm not going to say that on behalf of the county.
Thank you.
Is that reeling around it enough?
I've heard those kind of answers up here before, Mr. Tony. It's a good one.
And if I may, Mr. Mumford, I want to apologize for not following. Again, I can't answer for the county, and I did if I was out of turn by posing a question to the audience.
Right.
It was not my intention.
Okay. Thank you.
Further questions from the committee for Mr. Edwards with ACCG? Further questions? Thank you, Mr. Edwards. Chairman Knox. Chairman Knox, this bill came out of your subcommittee. Can you tell us what the recommendation of the subcommittee might have been?
That was a due pass, Mr. Chairman.
Okay, thank you. All right, anything further from members of the committee? Anything further? Vice Chairman Mumford.
I'd like to make a motion to table this at this time for further study.
All right. We have a motion to table House Bill 922. Motion to table. Secretary Bearden.
Motion to table overrides any other motion, correct? Would override any other motion?
That is correct. We will vote, we'll allow discussion, brief discussion. We'll vote that, and if it's successful, and if it's not, we will move forward. Any discussion on the motion? Vice Chairman Mumford.
I again want to thank my good friend Representative Jacobs for bringing this bill. I think that this is an issue that is worth monitoring. I think that the situation in DeKalb County needs to be looked into, but I think that we need to let this develop and see what comes out of that to see if there's some issue. I am a little bit concerned about the statewide effect of a law which would have thresholds which would differ from municipality to county to school board to other areas. But I want to again applaud Mr. Jacobs for bringing this bill. I think it is an important issue, and I know that his concern is to make sure that we have good government in DeKalb County and all over the state of Georgia.
Further discussion? Hearing none. All in favor of the motion to table House Bill 922, vote aye by raising your hands. All opposed, same sign. I think the motion is successful.
Did you count Ms. Benfield's child? She voted both ways.
That bill will be put on the table subject to further call.
I appreciate the committee's time. Thank you.
Thank you, Representative Jacobs. Anything else to come before the committee? Anything else to come before the committee? We will meet again. We'll get out an agenda tomorrow afternoon, and we'll meet again Wednesday at 2:00. Meeting's adjourned.